Thank you, Mr. Pincus. I now ask unanimous consent to enter into the record the following items detailing substantial compliance burdens as described by actual sellers experiencing them, highlighting the ripple effects of removing the physical presence standard in areas outside the sales tax and calling for congressional action to address these issues because of the effects on business growth and innovation. First, a statement by Jonathan E. Johnson III on behalf of Overstock.com. Second, a statement by Timothy B. Matthews, CEO of Jewelry Television. Third, a statement from Engine, which represents some of the most innovative and fast-growing companies in the country. Fourth, a letter from 16,000 Etsy sellers. Fifth, a statement of Hamilton Davison, President and Executive Director of the American Catalog Mailers Association. Sixth, the testimony of Terry S. Alpert, founder and CEO of Stony Creek Brands. Seventh, the testimony of William M. Garboz, President and CEO of Harriet Cater, Fresh Finds, and Wise and Well. Eighth, the statement of Steve Del Bianco, President of Net Choice. 9, statement of Douglas L. Lindholm, President and Executive Director of the Council on State Taxation. 10th, a statement of the Honorable Jimmy Hayes, former Congressman and former Commissioner of Financial Institutions for the state of Louisiana. 11, the testimony of Edward Bernert, who is chair of the State and Local Tax Committee of the American Bar Association's Tax Section. 12th, the testimony of Jessica P. Malujan, Associate Director of the Center for Technology and Innovation and the Competitive Enterprise Institute. And 13th, the testimony of Mr. Joseph Bishop Henchman, Executive Vice President of the Tax Foundation. We will now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself. And I have a number of questions, so I'd ask the witnesses to keep their answers brief so we can get through as many of them as possible. First, to you, Mr. Norquist, is there a real danger of retroactive tax liability for online sellers? Can you provide examples of states imposing retroactive tax liability either in the wake of the Wayfair decision or otherwise in the past?
Yeah, even before Wayfield, Washington State did back in 2015. Michigan did in 2016. These are states looking back as much as 23 years. Yes, it's been done, and there's no reason to believe that it wouldn't be done.
Mr. Cleland, does the bright line physical presence rule protect or undermine states' rights?
Well, I guess I would say pretty obviously it protects, in that the rule is clear, and other states can't, under a bright line rule, under physical presence that we've had to date, the Commerce Clause, states are not allowed to get into the business of businesses in other states.
Thank you. Mr. Moylan, conservative groups have long been hesitant to embrace most proposals in Congress to address the remote sales tax issue. What do you believe is the thinking now in that community?
Well, it's hard to know exactly. My hope is that you have consumer groups and policy organizations recognizing that there's a significant amount of turmoil that exists post-Wayfair. The answer has always been vested here in Congress, that Congress needs to act to place some reasonable structures that folks can abide by. And so while the landscape has certainly changed in terms of the political dynamics, ultimately the policy resolution comes from the same place, and that's Congress.
And Mr. Pincus, what are the ripple effects of removing the physical presence standard in areas outside of sales tax collection, and what sort of businesses should be worried about those effects?
I think there's a broad range, Mr. Chairman. For example, accountants, lawyers, doctors, architects, others who provide services over the internet, online education and training services, sellers of digital products, such as apps, online software services that are not downloaded but that are online services. Then there are questions, as has been raised earlier, about apportionment of corporate income taxes. I give an example in my written testimony, but there's a risk that as a result of this, as the Wells Fargo disclosure indicates, significant increases in duplicative corporate income taxes.
In light of the substantial compliance issues facing sellers and the lack of consensus from states on important details, some have called for a moratorium on the imposition of sales tax duties on remote sellers. Is a moratorium warranted, and is there a way to implement it that would be helpful and fair to all interested parties?
I think a moratorium is critical because history shows that without some kind of control, states go off the rails. Just to back up and give one example, Mr. Chairman, years ago there was a multi-state tax compact to deal with apportionment of state income taxes. The idea was to promote uniformity because there was a threat of congressional action. As soon as Congress didn't act, the number of states joining dropped away and the uniformity dropped away. So some kind of oversight and control is critical. I think a moratorium is one way to do it. Another way to do it is to create a vehicle so that if a state moves to impose a tax, there is an opportunity for those who are burdened to go to court and challenge it before it takes effect. As I said, a critical problem in this area is that for businesses, especially small businesses, there's no way to get their constitutional claim adjudicated. And so there really is no practical limit on the states.
The Supreme Court really didn't give much guidance or a practical approach to this, did they?
I'm sorry?
I said the Supreme Court didn't really give much guidance or a practical approach to.
No, the Supreme Court decided one thing: physical presence isn't required. It then left open 5 other questions about when a state tax obligation is constitutional and when it's not.
I want to ask a question. Mr. Sinowitz, Overstock told the committee that it received an estimate of $250,000 for compliance software and wound up costing $1.3 million. Jewelry TV told the committee it received an estimate of $2 million for enterprise software implementation. The project wound up costing $10 million, didn't work, and ended up in litigation. Is your confidence that you can get software for a modest fee based on actual installed costs or contract estimates in the contract?
I'm dealing right now with 3 different companies, and the average price of what I've been given with implementation is around $30,000, and after that first year, $20,000, because the implementation is a one-time charge. The fees that they want to charge are based on the fact.
So the answer is it's not done. You've been given promises, but you haven't got experience of implementation yet.
I've got statement of works on my desk. We're just deciding which company we're going to go with.
Very good. Senator Bramble, the NCSL recently issued guidance stating that the states should consider waiting until January 1, 2019 to begin sales tax collection requirements on remote sellers. Why is that waiting period advisable?
Thank you for the question. I think it gives sellers a reasonable period of time to ramp up their IT departments and such. But I'll tell you, as a CPA, in our state, the chairman of our state tax commission, who's a tax attorney with some 40 years in the profession, suggested very strongly that Utah adopt a October 1st deadline. The legislature didn't agree because we wanted to give a little more time to give businesses time to prepare.
Other than Utah, how many states of the 22 states with remote seller laws on the books are explicitly following the NCSL's recommendation of a January 1, 2019 start time?
I don't know the answer to that today.
All right, so in 2015, the state of Utah filed an amicus brief challenging a California law that applied California's cage size requirements to laying hens outside the state. Utah's brief argued horizontal federalism. In particular, Utah's brief stated that each state should not expect that their internal policies are dictated by another state where the first state citizens have no democratic representation. The brief noted that California regulators have already inspected egg producers for compliance outside of California. Do you believe that California regulators should be able to tell Utah farmers how to run their farms?
I think that's a false equivalency, Mr. Chair. I think that the issue of sales tax deals specifically with a tax imposed on a purchaser within the state of Utah, and if a business wants to take advantage of that marketplace, they comply with those laws.
You're not collecting that tax from the consumer. You're regulating an out-of-state business to require the collection of the tax.
The issue of taxation without representation, who is it that's voting for that tax, and who is that tax imposed upon? That's imposed upon the purchaser.
Who pays for the audit? Who pays for the fact that each jurisdiction has a different regulatory scheme on how to collect and how to remit?
We have that issue across the economy. Remote workforce is a good example. Utah chooses to not require withholding taxes and doesn't tax income earned in the state of Utah until an individual has been in the state 60 days.
So,
New York taxes the day you arrive.
I take it then that you you would agree with me that California regulators should not be able to inspect Utah farms for compliance with California cage size requirements.
Well, while I agree with that, I don't believe that that applies to the Wayfair case or the Quill case, and I believe it's a false equivalency.
All right, thank you. My time's expired.